Right now on the Daily Debrief.
I just felt like something wasn't right.
The mother of a child Georgia authorities say was murdered by her foster parents takes the stand against them. Also, a Florida jury asks for more information in death penalty deliberations. And the state stacks up evidence against a Tennessee man accused of murdering a girl who was homesick from school. Plus, an accused millionaire pedophile says he shouldn't have been arrested in the first place. The Daily Debrief recaps the day in court. It's Thursday, July 11th.
Good evening, everybody. Thanks for joining us. Mike Koribanics, good evening to you. We begin tonight with the trial of a Georgia couple accused of murdering their 2-year-old foster child. Joseph and Jennifer Rosenbaum face a mix of murder and other charges related to the death of Layla Marie Daniel. Authorities say the little girl died from blunt force trauma to the abdomen, a cut pancreas, and other abuse. The defendants say the girl died accidentally by choking on chicken. The state asked a responding medical emergency technician to basically debunk that theory.
So was she actively doing CPR to your recollection when you came in?
I didn't actually see her doing compressions and all that, but I remember seeing she was right there with the child.
But you didn't see her actively doing compressions?
No.
And once you come into the house, what do?
Well, basically, Brian, my partner, takes the child and he starts checking for an airway obstruction because that's what the call come out as, choking on a piece of food. And he's trying to clear the airway.
Lieutenant Gibson began to check the victim's airway. Mm-hmm. To your knowledge, was there any obstruction found by him?
Not that I'm aware of, no.
Did you see any vomit or any food particles around the child when you were there?
No.
That EMT continued by describing his own attempts to try to save the child's life.
Are you using one hand, both hands? What are you using to do your compressions with?
I'm using one hand.
Tell me how CPR works.
Well, we're doing compressions. It's on a child. It's like 30 compressions to 2 breaths. So I'm doing compressions on them. They're breathing her.
And about how long did you do compressions?
All the way to the hospital.
During the time that you were in the ambulance, did you have an opportunity to observe anything else about the child?
Well, she was in full view of me. So,
what did you observe at that time?
Well, she had bruises on her. That was probably the main thing that stood out.
Do you recall where you observed those bruises?
Yeah, they were some down around her diaper, top of her diaper line, on her wrist, her arms, legs.
Anywhere else did you see any bruises on her?
Yeah, they were on her back too.
Mm-hmm. During the time that you were in the ambulance and you were applying compressions, to your knowledge, does this child ever vomit or any food or any obstruction come out of her throat?
I didn't see it.
On cross-examination, this same EMT was forced to reconcile some of his earlier statements about whether defendant Jennifer Rosenbaum did try to save her foster daughter's life.
You testified here today that you did not see her doing compressions, that she had gotten up by the time you had gotten there.
Well, I just remember my partner saying that I believe he said she told him that she was doing compressions, but she was there by the child.
Isn't it true, Mr. Jones, that you wrote a statement about this case?
Mm-hmm.
Isn't that true?
Yeah, I believe I sent one in.
And isn't it true in your statement you said you saw the mother over the child performing CPR?
Yeah.
That's what you said back in November of 2015.
Okay.
Is that correct?
If that's what I wrote down, that's what I said. Yeah.
That's what you said, is that you saw her doing compressions on the child.
Well, I saw her over her.
What did you say in your report?
Yeah, I said I saw her saw the mother over the child performing CPR in the living room floor.
Thank you.
Yeah.
The county coroner who examined the child's body said he was concerned over the marks on the child's body. And then he described his interactions with the child's foster parents, the defendants.
Was the bruising that you saw consistent with other cases that you responded to where resuscitative methods have been used?
No.
Anywhere close?
No.
Did you ever interact with either Jennifer Rosenbaum or Joseph Rosenbaum on November 17th of 2015?
Myself, along with 2 other personnel, went into the quiet room and met with them. And that's the first time I had actually physically talked with her. She said that she found Layla in the high chair shaking when she came back from getting Millie ready to go, Mrs. Rosenbaum was going to go to a Board of Commissioners meeting.
And what did she say that happened after she came back from getting Millie ready?
That she saw the child shaking in the high chair. She picked the child up, called 911, and performed CPR, and until the EMS arrived.
And that was the history that you received from Ms. Rosenbaum?
Yes, and that she was possibly choking on chicken nuggets.
Did that history appear to be consistent with the examination you did of Layla Daniel in the hospital that day?
Not really, no.
The victim's biological mother testified that she fell upon hard times and felt that fostering her children was her best option. At first, things went well.
How did you know what was going on with her to make you feel comfortable?
I just looked at all her pictures of her and Joseph and their dogs and stuff, and I don't know, I just felt like they just looked like good people. And I felt like maybe if she knew me and reached out to me, that maybe I didn't have the best memory, but I figured that she couldn't mean nothing bad by that. Like, I felt like she had to have good intentions if she reached out to me.
Did you feel like your girls would be safe with the Rosenbaum?
Yeah.
Did you know Joseph Rosenbaum?
No, ma'am.
Had you ever met him before?
No, ma'am.
After May the 20th, did you have any more contact with Ms. Rosenbaum?
Of course, a lot, because she started getting visitations with the girls, and she was the closest thing. And since they had been taken from me by defects, this was the first time that any of the actual people that had them would actually tell me things and update me. And she was a really uplifting person with her words, you know, whether she,
And the contact that you had with Ms. Rosenbaum, what was your main source of contact with her?
It was Facebook Messenger.
And how often would you Facebook Messenger with Ms. Rosenbaum?
Well, she's a talker, so a lot.
As displacement continued, the victim's biological mother became increasingly worried about the victim's health, and she began recording her phone calls with at least one of the defendants. She said her child was losing weight and at one point had to go to an urgent care facility.
Once I started feeling like Layla was sick too much, I started feeling like she didn't send me pictures of her. I just wanted to know, I just felt like something wasn't right. So I wanted to keep, because, my memory isn't all that great. So I wanted to make sure that I had everything that we talked about in order to go back to it in case I needed to.
And why did you become concerned?
Well, because Millie, I had a phone call. The only time Millie ever, wasn't calm and cool in a phone call, I don't know why it was this night of all nights, but she was just frantic and she was hysterical, really, talking about how much she missed her old people, talking about me and my mom, and she was talking about that she just wanted to see us.
Do you remember when that conversation was with Millie?
I can't remember an exact date, but I know that it was, I started recording the phone calls after that.
Attorney Mike Koribanics with me tonight here on the Daily Debrief. So Mike, we're talking about warning signs here. Is there anything that could have prevented this?
Well, it just seems it's very difficult to see why this young mother, even though she gave up for foster care, she still had a finger on the pulse, for lack of a better term, and she had all these warning signs that something wasn't right, and she just didn't act on it. And it's very, to me, this is very disturbing testimony.
Oh, terribly disturbing. We've got two defendants here. We have the wife, the female defendant, present when this episode happened, okay, if we can just call it that for simplicity. The husband not present. Bottom line, legally, this changes a lot of things when you have two defendants sitting in the same courtroom, especially when they're spouses.
Well, it changes things, and like I said before, Aaron, I can't get over that you have two defendants being represented by one attorney. I just think this is a built-in mistake on the part of the judge and the prosecution and the defense. And regardless, if this case is a conviction, I will bet everything that it's coming back on an appeal.
Yeah, that's a dangerous tactic, because, I mean, what happens if one of the defendants has to blame the other or testify against the other? I looked up the Georgia law on this. Of course, there's a spousal privilege everywhere I've ever examined, okay? But in some states, and Georgia is one of them, in the case of a child abuse prosecution or something involving a young victim, the state can go in and invade that. The state could force one spouse to testify against the other.
But I still don't see how they get around the fact that they're not having independent counsel to look out for their own best interest. Because they just by the very fact of that scenario, you can't have one attorney arguing for both of them. Because one's going to want to waive the privilege and the other one's going to keep the privilege.
Potentially.
It becomes a mess. And it's a mess that could be avoided by just giving each defendant their constitutionally guaranteed right under the Sixth Amendment to independent counsel.
Exactly. I agree with that assessment. It seems to me that there must be some facts under the surface that we are not privy to or that we have not yet heard. So we will keep an eye on things. Mike Koribanics will be back to you in just a second. A Florida jury is deciding the punishment of a convicted murderer, who took the stand and said he was a homicidal maniac and wanted to be put to death. Scott Nelson blamed his probation officer for setting him off when he admitted he killed Jennifer Fulford, a personal assistant to a wealthy man. He called Fulford, quote, collateral damage because he needed money. Nelson's defense team has already filed a motion for a new trial, even though the punishment isn't even in yet. And these are some of the reasons that the defense team is giving. Among the reasons here, number 3, the court should have thrown out the defendant's confession. Reason number 5, the court should not have allowed the knife, the murder weapon, into evidence. Number 6, the jury shouldn't have heard that the defendant's police interview was conducted in jail. So those are some of the reasons the defense is giving for exactly what's going on here. A lot of questions from the jury popping up in this case. Bottom line, the jury asking for copies of the Diagnostic and Statistical Manual of Mental Health Disorders and a readback of testimony involving bipolar disorder and PTSD. Of course, the jury did get the readback of testimony after the court prepared it, but the judge said, look, you have to decide this punishment phase of the case. Is it life? Is it the death penalty? Based on testimony in trial, not all this other research that you're asking for. You have to rely on what's been presented in the case. This deliberation rolls along into the evening. And still ahead tonight here on The Debrief, new court documents explaining some of the defense strategy in the case of alleged millionaire pedophile Jeffrey Epstein. Also, testimony in the trial of a Tennessee man accused of murdering a girl who stayed home from school because she had been injured. That case when we return. Welcome back, everybody. Lawyers for accused millionaire pedophile Jeffrey Epstein say he should be out on bail pending trial on sex trafficking charges and that he should never have been charged in the first place. Chief Investigative Correspondent Brian Ross has a look inside the defense strategy laid out in new court documents filed today. Brian, good evening.
Well, good evening, Aaron. The lawyers have made their case. They say that the accused sexual predator should be free on bail while he awaits trial on the sex trafficking charges, claiming the government was wrong to say that he's a flight risk or a danger to the community. But this is what the U.S. Attorney Jeff Berman said about that earlier this week after Epstein was arrested.
And flight risk, and that is why we are seeking detention pending trial. He has enormous wealth. The charges are very serious, and they carry with them a maximum sentence of 45 years in jail which to someone of Epstein's age is basically a life sentence. So we think he has every incentive to try and flee the jurisdiction. And when you have 2 planes and you live much of the year abroad, we think that's a very real risk.
He is a, quote, law-abiding citizen who has a spotless record, they say, of walking the straight and narrow. And in a letter to the judge, the lawyers say that Epstein is prepared to wear a GPS ankle bracelet, hire his own armed guards, and even put up his $77 million mansion and perhaps his private jet as collateral to make sure he does not flee while he awaits trial. But the lawyers say he has a spotless record of walking the straight and narrow, and that he is a law-abiding citizen. The lawyers say in a letter to the judge that, in fact, they'll put up his $77 million mansion, he'll hire his own armed guards, and wear a GPS ankle bracelet. The lawyers also claim their defense strategy is that he never should have been prosecuted in the first place, that he has already been punished and prosecuted for charges going back to Miami when he entered a guilty plea for minor state charges. The lawyers also say they will challenge the fact that he's a sex trafficker in a classic sense, that his crimes are mostly of a state and local nature, Aaron.
So, Brian, Epstein's putting a lot of money on the line to try to basically get out of jail pending trial. The question is, will that strategy work?
Well, that's a very good question. There is a whole dynamic here about should the rich be able to buy their way out of jail. The prosecution says this is a man who could easily flee, especially since he faces up to 45 years in prison. And for a man who's 66 years old, like Epstein, that could be the rest of his life, Aaron.
Exactly. And of course, we also have the question popping up in my mind, okay, is he going to flee to a country that does not have extradition treaties with the United States? That would require some more research. Also, the double jeopardy argument is interesting legally, Brian. He's trying to say, look, I went through this in Florida. Federal charges dropped, state charges stuck. I served about a year in a local jail down there. Should that cover everything that he's being hit with now? It seems to me that these are pretty different charges.
Well, they are, but Epstein claims it's unconstitutional what's happening to him, that he was punished for this, he was prosecuted for this, but the deal he made with the federal government was only with the U.S. Attorney's Office in the Southern District of Florida, Miami. It does not bind the people here in New York, and that's their argument, Aaron.
Brian Ross in the newsroom tonight. Thanks for that. The Arizona teacher who admitted to sex crimes involving an underage student will be sentenced tomorrow. Brittany Zamora will likely be sentenced to 30 years in prison under a deal worked out with prosecutors. A local newspaper is reporting that police records indicate Zamora may have been grooming a second victim. Cameras are allowed at the sentencing, but live coverage is not. We will bring you the statements and the sentencing as best we are able tomorrow here on The Debrief. And now to the case against a Tennessee man accused of murdering a 12-year-old girl. Roy Coons Jr. is accused of killing 12-year-old Joanna Arteaga by beating and strangling her. Arteaga was home from school because she had hurt herself while she was roller skating. She texted her mother that someone was knocking on her door at 4:15 p.m., whom she thought was the person who mowed the family's lawn. Her mother found her dead 2.5 hours later. The prosecution says the girl's attacker pried open a window and that the defendant's DNA was on the window frame. Testimony about that window occurred this morning.
Can you describe what you were able to recover, if anything, from this particular window?
As far as fingerprinting this item, there were no latent prints developed. And then areas were swabbed. The latch areas of the frame, there were swabs taken. There were swabs taken from the frame itself. And then there were swabs taken on the glass, some smudged areas on the interior side.
Was this just one smudge or multiple smudges, or anything that might tell us potential sizes, whether that would be consistent with the size of fingers?
I don't know that I could answer that exactly.
Now, have you, when processing scenes in the past, have you had opportunities to observe smudges on items that you've processed for latent prints?
Yes.
While it cannot be definitively shown, can that be consistent with gloves?
Could be, yes.
The defendant's DNA also turned up on a cigarette found nearby.
The state asked you about a cigarette butt that you recovered. Your report indicates you found that at lot C4. that accurate?
That's where, yes, that's where I was requested to go to.
Okay, so that wasn't a cigarette butt that was found outside of the trailer C2 when Ms. Ortega's body was found?
No, sir, it was in the roadway area.
Near lot C4?
Yes, sir.
Do you know who lived in lot C4?
I have no knowledge.
Was there a chair outside of that master bathroom window that you were asked to process?
Without seeing a photograph, I don't recall one, but I'm not saying there wasn't.
Your report doesn't reflect that you processed, did any processing, is that right?
Of the window?
Of any chair outside that window?
No, I didn't. I don't recall processing a chair.
The prosecution has said that the victim's DNA is also on, or rather the defendant's DNA is also on the victim's body, but that information has not come out yet on the witness stand. And the victim's sister took the stand to describe her family's interactions with the accused killer leading up to her sister's death. We could not show you her face, but we can let you listen to her testimony.
During the time that you would be home alone with your sister or your brother, did you ever allow Mr. Roy Coons to come inside the trailer?
Never.
Did you or your brother and sister in your presence ever hang out and laugh and shake hands with Roy Coons?
Never.
In what kind of situation would you ever see Mr. Coons?
When he was outside, usually it was always outside. When my mom would talk to him about mowing our yard, things like that, yeah.
Was he someone that you would go up and have conversations with or talk to?
No.
Attorney Mike Koribanics back one last time for some quick comments on this case. DNA on the cigarette nearby, on the window, and on the victim's body. That's what we have on the witness stand thus far, but the prosecution is promising us that the defendant himself also made all these bizarre comments saying, you know, can I be forgiven for killing someone? That may be the testimony that seals this up.
That's very difficult. Even though the other is scientific and very much to the point and can be with an expert, it's those admissions against interest, which the law allows in as non-hearsay, that could be really devastating to a defendant.
Exactly. Mike Koribanics, thanks for joining us on The Debrief, and thanks for those of you watching along with us. Our live trial coverage picks up at 9 o'clock tomorrow morning. The Debrief will be back tomorrow at 5. Good night.